Florida's Sunshine Law. Florida's government, in the Sunshine Law, provides a right of access to governmental proceedings at both the state and local levels. In the absence of a statutory exemption, it applies to any gathering of 2 or more members of the same board to discuss some matter which will foreseeably come before that board for action. Scope of the Sunshine Law. Board members may not engage in private discussions with each other about board business, either in person or by telephone, email, texting, or any other type of electronic communication such as Facebook or blogging. While an individual board member is not prohibited from discussing board business with staff or non-board members, these individuals may not be used as a liaison to communicate information between board members. For example, a board member cannot ask staff to poll other board members to determine their views on a board issue. The Sunshine Law applies to advisory boards created pursuant to law or ordinance or otherwise established by public agencies or officials. Staff meetings are not normally subject to the Sunshine Law. However, staff committees may be subject to the Sunshine Law if they are deemed to be part of the decision-making process, as opposed to traditional staff functions like fact-finding or information gathering. Board meetings. While boards may adopt reasonable rules and policies to ensure orderly conduct of meetings, the Sunshine Law does not allow boards to ban non-disruptive videotaping, tape recording, or photography at public meetings. Public Records Law. Florida's Public Records Act, Chapter 119, Florida Statutes, provides a right of access to records of state and local governments, as well as private entities acting on their behalf. If materials fall within the definition of a public record, it must be disclosed to the public unless there is a statutory exemption. The term public records means all documents, papers, letters, maps, books, tapes, photographs, films, sound recordings, data processing software, or other material, regardless of the physical form, characteristics, or means of transmission. This includes electronic communication like text messaging and emails, made or received pursuant to law or ordinance, or in connection with the transaction of official business, by an agency, including a private entity action on behalf of a public agency, which are used to perpetuate, communicate, or formalize knowledge. Providing public records. Public records cannot be withheld at the request of the sender. A requester is not required to show a legitimate or non-commercial interest as a condition of access. A request cannot be denied because it is overbroad. Unless authorized by another statute, an agency may not require that public records requests be in writing or require the requester to identify himself or herself.